Welcome to Shenkman Education. My name is Marty Shenkman, and the topic for this video clip is self-settled domestic asset protection trusts, commonly called by the acronym DAPT, D-A-P-T, although there's some variations. If that sounds technical and like a mouthful, don't tune out, because it's really an important planning tool for a lot of people. Those looking to protect assets from lawsuits and claims, those looking to protect their assets before a coming up marriage, single people that need to protect assets or want to save estate tax. There's a lot of very important uses for this technique. What is a self-settled domestic asset protection trust, or a DAPT? And if you're a doctor, it's not dual antiplatelet therapy. It's a different concept altogether. So we live in a dangerous world. Dangerous, right? There's vultures, dinosaurs, dangerous things out there just ready to grab you. We live in an incredibly litigious society. It's not going to change no matter what happens in Washington, no matter what happens with the tax law. So it's incumbent upon anybody with any level of wealth, not just the uber wealthy, but especially for those as their wealth level increases, to try to protect that wealth. There's lots of things you should do. It shouldn't just be this type of trust. Again, people often look for, the magic trust that solves all their problems. You want to operate your business wisely. You want to have proper insurance coverage. You want to have entities formed to hold a business or real estate property. We're not covering that, but all those basics need to be addressed before you look at, and in addition to looking at a self-settled trust. What's a self-settled trust? First, a domestic asset protection trust. Domestic means it's in the U.S., it's not overseas. For many, many years, people have created offshore or foreign asset protection trusts. There's certainly an advantage to that. It's more costly, more complicated, requires even greater expertise and actually moving assets offshore. And many people still do that. A domestic asset protection trust is created in one of approximately 20 states in the U.S. that permit these types of trusts. What is a self-settled trust? I create a trust for me, you create a trust for you, and you remain a beneficiary of the trust you create. That's why it's self-settled. You settled it, you created it, you funded it, but you remain a beneficiary. Why might you do that? Properly done, you can move assets out of your estate for estate tax purposes, yet remain a beneficiary. Properly done, you can move assets into a protective structure that you can benefit from, but your creditors can't reach. I thought the guy was moving behind me. I thought I heard something. Got to get my trust set up. So you can create a trust in one of these jurisdictions. Alaska, Nevada, South Dakota, Delaware have been the most common in some of the earliest jurisdictions, but Michigan, New Hampshire, Tennessee, all have statutes that permit this. It's not a one-off thing any longer. In 1997, I believe Alaska was the first state that created this type of statute to permit this type of trust, but it's grown to nearly 20 states. Many lawyers and advisors feel these trusts are simply too risky to do and won't do them. There is certainly merit that there is risk, but you need to weigh the risk versus the potential benefits. And if you can have assets that are protected from claimants, if you can create a structure that you can benefit from, but maybe it's outside your estate, yes, there may be some risk, but you need to balance those. One of the questions or issues or risks that have been talked about really since the inception of these domestic asset protection trusts in 1997 has been the idea of the full faith and credit clause of the Constitution. So if I create a trust in Nevada, but I live in California, and California doesn't permit these types of trusts, will California disregard the trust and apply California law? There was, I believe, only one such case, and it was called Huber, where a court applied the law of Washington and disregarded an Alaska trust. I believe that trust case was wrongly decided. In the Huber case, the individual setting up the trust was in a lawsuit with his business partner, was in default under, I think, 3 bank loans at the time he set up the trust. Those transfers that individual in that case made were fraudulent conveyances. He was trying to defraud his creditors by keeping his assets away from what were then known creditors. So I'm not sure how appropriate it might be to apply that case. In the almost 30 years, I think it's like 28 years since the first statute was enacted in Alaska, I'm not sure there's really any other cases. There was recently a case in Delaware that upheld an asset protection trust but didn't address that issue of application of state law. And it's not clear what that means. Leaving aside these complications, let's say you live in a state that does not permit these trusts, New York, California. So you can create a trust in Nevada, Alaska, South Dakota. You name a trust company, an administrative trust company or a full service trust company in that state, and you can create the trust, put assets in it, and hopefully gain these really dramatic benefits. If you live in one of those 20 states, the planning is even more secure because this full faith and credit issue doesn't exist. Why wouldn't you pursue this planning? So it's really an incredible planning opportunity, not without risk, not without cost, not without complexity, for the right people with the right circumstances. If you're a young physician, create a trust today. The recent Delaware case really emphasized that the person that created the trust in that case had set up the trust years and years before even the business venture that led to the claim that he was being sued at arose. So you want this type of trust planning in place long before you have a real issue or problem. There's a lot of steps you can take to enforce and enhance this planning. Have a financial forecast done by your wealth advisor showing that you don't need for the foreseeable future for many years the assets going into the trust. Maintain sufficient assets outside. Get lien judgment and creditor searches before you fund this type of trust, showing that you have made a good faith and serious effort to demonstrate that you have no claims. Put together a balance sheet that shows your net worth with and without the trust assets that you're going to transfer. Make sure that you can, if you can, use underlying entities. So let's say you have a real estate property, you can't transfer that or shouldn't transfer that to the trust directly. It should be an entity like a limited liability company known by the acronym LLC before being transferred in. Make sure you adhere to all the formalities of the trust. Don't get funky with how you handle trust matters. If you want a distribution, and ideally you shouldn't take one for as long as possible, if ever, but have the independent trustee make those decisions, not you. Make sure that if anything is done where you make an investment in the future with trust assets, the trustee signs things with appropriate formalities. One of the key applications of this, not everybody is married. So much of estate planning focuses on a nuclear family, a married couple, spouses, husband, wife, and I don't remember the statistic offhand, but a nuclear family is far less than half of the family units in our country. So if you don't have a spouse and you can't qualify, for example, for an unlimited estate tax marital deduction and many of the other state law benefits to having a spouse, using a self-settled trust may be really a valuable tool for you. It's not inexpensive, it is complicated. You don't want to do it, half planned. You want to really do it right. But if you do, and it makes sense for you, it could be a really powerful planning tool. And this, as an example, so many people talk about revocable trusts as being an estate planning tool that you have to use. Yes, avoiding probate can be fine, but if you don't have assets left, what probate are you going to have? So really evaluate asset protection planning. Start with the basics that I mentioned in the earlier part of this video clip. And if in fact this type of self-settled trust makes sense, go for it. Last comment. There's many different variations of this. They're not standard types of trust documents or planning. You can do, for example, what some people call a hybrid DAPT or self-settled trust. So I'm not a beneficiary of my trust today, but I named my college roommate Joe to be a person holding a power to add back descendants of my grandparents, and gee, that includes me. So in the future, if I really need access to the money, Joe can add me back. Hybrid DAPT. It's not uncommon to have a deferral period in the trust of 10 years and a day. Under the bankruptcy code, if you make a transfer to a self-settled trust or similar device, and I'm not sure we still know what a similar device is, the bankruptcy trustee can disavow or negate that transfer. So if you can't become a beneficiary for 10 years and a day, and a bankruptcy trustee can only unwind that transfer for 10 years, if you end up in bankruptcy, you may avoid that as well. There's another concept called a special power of appointment trust, known sometimes by the acronym SPAT, S-P-A-T, where instead of my college roommate being given a capacity, in a non-fiduciary capacity, the power to add me back as a beneficiary, Joe is given the power to direct the trustee to make a distribution to me. It's called a limited or special power of appointment in the law. So, to summarize, if appropriate for you and your circumstances, evaluate using a self-settled trust. It could be a very, very powerful planning tool. Thank you for joining me, and please remember that all the video clips on Shenkman Education, this video clip are for educational purposes only. Don't take any action without consulting a professional advisor. And listen, this particular topic is really complicated. You need not just an advisor that's professional, but you need someone that has some specific expertise in this technique. Thank you.